Today, we are very lucky to have with us Damon Barrett, and I'm just going to tell you a little bit about him. Damon Barrett is the co-director of the International Center on Human Rights and Drug Policy, which he co-founded in 2009. He is an associate senior lecturer at the School of Public Health and Community Medicine at Sahlgrenska Academy, I hope I pronounced that right, at the University of Gothenburg. Prior to moving into academia, Damon was Deputy Director of Harm Reduction International in London. He's joined us today to discuss his most recent book, Child Rights and Drug Control in International Law. Welcome, Damon, and thank you for making the time to be with us today. Just for all of our guests to know, myself and my library staff, so Patrick and Chris, will be monitoring the chat and as well as anybody who wants to raise their hands. We're going to hold a 15-minute session after Damon speaks for you to have the opportunity to ask questions, but we will be monitoring it in the meantime. So without further ado, I will pass things over to our guest speaker. Thank you so much, Damon.
No problem. Thanks, Giovanna, for the invitation, and to Patrick as well, and to your colleagues at the library. It's I'm glad you're doing these talks. I think it's a good way to use the library resources and combine things. And welcome to everybody there. I'm guessing a lot of you are in Vienna, which I miss now under COVID. I would normally be at the Commission on Narcotic Drugs every year and enjoying Vienna, and I've missed it since in the past 2 years. So I'm going to talk about my recent book, which grew out of my PhD studies at the University of Stockholm, in fact. And I'm going to broadly talk about 3 questions, not getting into a ton of depth on any of them, but there are 3 things that really come up in the book. One of them is this idea of when and how did drugs get into international child rights law via the Convention on the Rights of the Child, and conversely, when and how did children come into the UN Drugs Conventions? The second thing I want to look at is what does child rights law require in relation to drug policies? But I'm not going to do that in a very legalistic and doctrinal way, because I don't in the book. Instead, I'm going to look at the way that question has been approached by activists, by policymakers and others in the drug policy space, and how those differ, which I think is important to bear in mind. And the last thing I'm going to look at is how states and the UN Committee on the Rights of the Child have looked at this provision in the Convention on the Rights of the Child, which I'll get to later, Article 33, on the protection of children from drugs. And what does that tell us about the relationship between international drug control legislation on the one hand and child rights law on the other? I guess to begin with, then, we should probably ask why focus on children. Beyond the obvious that we should be protecting children, of course, we have to look at the ethical and legal and practical challenges involved in protecting children from drugs and how that differs from adults. As well, we have in the Convention on the Rights of the Child a genuinely unique provision in international human rights law that doesn't really have an equivalent in the other main UN human rights treaties, and that is increasingly prominent in global drug policy debates. I mean, we've seen some of the more controversial resolutions at the Commission on Narcotic Drugs in recent years, in fact, having to do with this question of protecting children. So there's a good reason to focus on it now. So let me have a look at the history of this a little bit. How did drugs get into international child rights law and vice versa, children into the drug control system? So I have a couple of pictures here. Don't take the pictures too seriously. I'm not going to focus on each one individually or anything. They're just there to represent the passage of time, and they represent the parallel development of child rights on the left and drug control on the right. What we see in the early days of drug control, all the way back to the Shanghai Commission, is very little interest in children, in fact, which is not to say the concern wasn't there. The Royal Opium Commission in India did spend quite a bit of time on opium use, among children. and children's involvement in the opium harvest. It just didn't come up in the Shanghai Commission that really led to the genesis of international drug control. During the League of Nations period, within the covenant of the League of Nations was mandated with both child welfare tasks as well as opium control tasks. But there wasn't really any crossover within the League Secretariat with regard to child welfare and opium questions. They had two sections and they didn't really cross over very much on this question. As part of my research, I went through the official records of the League of Nations over the years of its running and didn't find any crossovers, despite a few efforts to look at alcohol in the family, for example. But during the League period, there were two treaties adopted that referred to minors specifically. The first was the 1925 Opium Suppression Treaty, which aimed to prevent and prohibit sales to minors, which was an early provision relating to this age group. Didn't define what minors were, but let's assume legal minors in the relevant country context. And the other treaty was the 1931 Opium Smoking Suppression Treaty, where under 21s were prevented from purchase and from accessing divans. And there was an early prevention provision, believe it or not, in the 30s there, about suitable instruction in the schools, which is how that's worded. Now, the reason that it was those two treaties that this turned up in was that these related only to colonial territories at the time. These are not the kinds of things states were willing to take on board at home, those who were the colonial powers at the time. But one of the reasons to mention those treaties too is there was no other explicit mention of minors or children in any of the drugs treaties from these all the way through to the 1988 Trafficking Convention. But also, while these days prevention is something we easily talk about, back then governments were very cautious about prevention and were of the view that if it was mishandled, if there wasn't already widespread drug use, that prevention could actually be harmful, or propaganda they called it at the time. And prevention would really remain controversial all the way into the 1960s, in fact, throughout the debates of what we now see to be the main drugs conventions. Parallel to this, and this is one of the photographs here, is in the top left, it was the adoption of the Declaration of the Rights of the Child in 1924. That picture there is Eglantine Jebb, who was the founder of the Save the Children movement and drafted the declaration. It's only a 5-point declaration. It's very short. It was adopted at the League of Nations, and it doesn't mention anything to do with drugs. Now, that might seem obvious. They were dealing with the fallout of World War I, but there was a much longer draft that was also prepared, which included a lot of detailed issues around child labor, around the conditions in the home, and that also didn't deal with this question of substance use. Again, the League was engaged with bigger issues. On the opium side, it was more concerned with supply reduction, and it was, in terms of health, it was more concerned with hunger and typhus and these larger issues than this. So the issue during the League was just not on the agenda in the way that it became in later decades. Taking a time leap here, none of the drafts of the single convention on narcotic drugs referred to minors or youth or children or any formulations that would direct us to this population. The only substantive debate that happened around including provisions related to young people was Hungary's suggestion to include a prohibition of incitement to use drugs or encouragement to use drugs to be backed up by severe penalties. But that wasn't taken up. Otherwise, the only real mention of young people was in passing in certain speeches, and not that many at that, no more than 3 or 4. In fact, just to show how little this was on the agenda at the time, between 1946 and 1961, over 270 resolutions about drugs were adopted in the UN system, and none of them referred to this age group. Again, in parallel, the Universal Declaration of Human Rights had been drafted and adopted in 1948, and the main commentary on the travaux préparatoires on the Universal Declaration says that states had demonstrated, and the drafters demonstrated, no interest at all in the topic of drugs. Again, I would have to say that this seems obvious given the times and that this was a post-World War II document, but so was the European Convention on Human Rights, and that does include a reference to, quote, drug addicts as a grounds for the deprivation of liberty. So the issue was not entirely absent from human rights law at the time, just not relevant in the drafting of the Universal Declaration. So the single convention in its original form in any case doesn't refer to this age group. The situation changed very, very slightly with the 1971 convention drafting process. There we see Sweden as one of the countries spearheading the need to take international control of synthetics, partially because of a very prominent death of a 17-year-old girl as part of an amphetamine prescription program at the time. But even then, when young people were mentioned in the drafting process, it remained rhetorical. There wasn't really much of a focus in any substantive sense on what would be needed to protect children and young people. So, for example, the Canadian delegation said that the very population that the conference had been brought together to protect was young people. There were still no substantive provisions focusing specifically on them. Late 1971, things change a little bit because the UN General Assembly adopts its first drugs resolution focusing on young people specifically. And that resolution also marks a change in tone for the United Nations resolutions about drugs. Previously, they were very technical, very bureaucratic. The late 1971 resolution on youth really shifts into a threat narrative. And all of a sudden, the discussion is about the threat to the fabric of society posed by drugs, which sets the tone really for the negotiations of the 1972 protocol, which was intended to strengthen and improve the single convention. And there, young people are in focus a bit more. And there's more of an interest we can see from states in talking about treatment and prevention as part of a treaty discussion. This really hadn't happened in the same way previously. And we do, in fact, see through the protocol and the 71 treaty a vague, I would say, provision seen in the commentaries to the conventions as no more than a recommendation to focus on prevention and early identification. But in the drafting of those provisions, young people didn't really arise. So it's an implicit reference to young people in terms of prevention, but it wasn't discussed in that way. In fact, in drafting the 72 protocol, the two big issues that related to young people that came up were the debate around addressing root causes of drug use and dependency. And the other one was this question of incitement coming up again. So the Holy See, backed by certain other countries, including the Soviet Union and Venezuela, really wanted to focus in the treaty system on the root causes, the social factors that led to problematic use. But the consensus view, or rather the majority view, was that that wasn't the mandate of the treaty conference. And here, though this frustrated some of the delegations, what we can see is that states were not willing to talk about the kinds of legal obligations that would go into social change in a treaty of this type, which actually mirrors at the time some of the concerns some states had with adopting the Covenant on Economic, Social, and Cultural Rights. The other question was incitement. And here, it was Costa Rica that wanted to see a strong provision prohibiting incitement to use drugs with the express intention of protecting young people. However, the Netherlands and Denmark and some other states pushed back against this on freedom of speech grounds. So here we can see already a tension. But in fact, these are both rights issues, social and economic rights in terms of root causes, but here civil liberties in terms of freedom of speech, and what kinds of human rights costs would be acceptable in order to respond to drugs questions. Ultimately, the incitement idea was defeated, but it wasn't defeated substantively. It wasn't defeated argumentatively, I should say. Rather, another state simply came in with a different proposition that omitted it, and states went with that instead. So the question was kind of left unanswered, and it would come back up again later on. Again, mirroring this, the UNICEF had been created in the 1940s, and by this stage in the 70s had been going for almost 30 years. And in 1973, to follow up on that General Assembly resolution, which I mentioned, the UNICEF Executive Board included drug abuse, quote, in its agenda for the first time. But similar to the concerns states had about prevention, about whether they knew enough to do anything about it, there was caution about UNICEF taking on board this question of drugs, whether it was in its mandate, whether it had the right expertise, and whether states really knew enough to take any action at the time on youth drug use. There was a huge data problem at the time, or rather an information problem. States didn't really have a clear picture of what was going on in their countries. From then, UNICEF drops the question until into the 1980s, in fact. By the 1980s, we should say, the situation in relation to drug use, in relation in particular to trafficking, was worsening. We see the Cali and Medellin cartels becoming more powerful, being seen as narco-terrorists at this point, especially in the late 1980s with the blowing up of a passenger jet. And it was in the early half of the 1980s that there were calls for a new drug trafficking treaty. In fact, this was tied up with what eventually became the Rome Statute of the International Criminal Court. But where young people come into this is that there were calls to see drug trafficking as a crime against humanity on the basis of the threat that drug trafficking posed to young people. So this was an interesting, very, it gives us a picture of the attitude at the time. The concerns about traffickers and where young people were coming into that. So the 1988 drug trafficking treaty is in a way a creature of that time. And we all know it includes the more punitive elements of the drugs conventions. It's an instrument of transnational criminal law. And it's here, although there was reference to prevention in earlier treaties, here we see the first explicit reference to children or minors or young people in any of the drugs conventions. So the preamble refers to the threat to children posed by their being used as a consumer's market. It's the wording there. And their exploitation in the drug trade as a danger of incalculable gravity. So here we can see the kind of narrative that had developed since the early 70s. Later on in the article in the Convention on Penal Measures, Article 3, we see children referred to in terms of what would it become aggravating circumstances for a stricter sentence or penalty. So this included, for example, the victimization of children in the commission of the crime, which mirrors national law in many countries, but also the location where certain offences would take place, which would include areas where children and young people congregate to socialize, which some states objected to. They said that would be far too broad to mean that a more severe penalty should be applied just because a crime was committed in an area where potentially young people congregate. The other provision that I say explicitly refers to young people, it in fact doesn't, but the whole reason for the provision is the protection of young people, is the provision on incitement to use drugs. So whereas this was rejected in this drafting of the single convention, it never came up in the 71 treaty. It was rejected in relation to, well, it didn't get through in relation to the 71 protocol. Now it got through with ease, and the freedom of, what's interesting is the freedom of expression concerns that were raised in the early 70s were no longer there. They didn't arise at all. So the provision effectively, it was introduced quite late in the drafting process, and it effectively went through without any objection. Again, we have a parallel process, and here I've got a nice picture of Audrey Hepburn and the then head of UNICEF at the adoption of the Convention on the Rights of the Child. Now, there had been a declaration on the rights of the child in the 1950s that built on the earlier League of Nations declaration, but again, it didn't include this question of drugs. However, the drafting of the Convention on the Rights of the Child had begun in 1978, and already the first submissions from states and NGOs included at least an interest in seeing the question of drugs included, which I found out having spent quite some time in the archives in Geneva, which was a really wonderful experience, in fact. However, it wasn't until 1982 in the drafting that China suggested some wording on this. And this was around the time that China was really taking an interest in the drug trade, and the same year, in fact, that it had developed its first specialized drugs police force. And the wording, which was then part of the right to health, was to prevent and prohibit children from using drugs. Pretty simply straightforward. Some other suggested wording came up over the next couple of years, but it was never debated until 1986, when we have the main debates in the Convention on the Rights of the Child process. Here we have a longer two-paragraph suggested article from China, again, intended as a standalone article now. And here for the first time we see this idea of children being protected both from drug use and involvement in the drug trade. Now, it's in the preamble of the '88 Convention, but this debate's taking place 2 years before that. The Chinese wording also included treatment, and it included strict penalties for those who use children in the drug trade or incite them to be involved in the drug trade or to use drugs. So this question of incitement, again, came up. Now here, interestingly, incitement was rejected. It got accepted into the '88 Drugs Convention. It got rejected from the Convention on the Rights of the Child, as did the mention of stringent penalties, which, as I'll get to in a moment, I think speaks to the kind of treaty that was being negotiated. One is a transnational organized crime treaty. One of them is a child rights treaty. They're not the same thing. Eventually, what we ended up with was a blending of the Chinese suggestion with the ad hoc NGO group's suggestion to come up with what we now have in Article 33 of the Convention, the text of which I'll show you in a moment. The final discussion around that provision, in fact, was the World Health Organization. There was as we'll see, there's a phrase in the article that refers to protection of children from substances as defined in the relevant international treaties. And there's a submission from the World Health Organization clarifying that the relevant treaties in this case are the 61 and 71 conventions, which effectively excluded alcohol and tobacco from the remit of Article 33, which doesn't mean it's excluded from the child's right to health otherwise, but there weren't any treaties on those at the time. So just looking at these two drafting processes, now I know I've gone through almost the whole 20th century in a couple of moments there, but between the 1988 and the Trafficking Convention drafting and what preceded it, and the drafting of the Convention on the Rights of the Child, there's one or two kind of observations we can make. One that's interesting is, as I mentioned, the Convention on the Rights of the Child's Article 33 predates the preamble of the 1988 Convention by 2 years. Now, I haven't been able to find evidence of it, but the fact that it came prior, and the fact that there were some of the same prominent states in the drafting of both, and the fact that some of the same NGOs were involved in both, suggests that it could be that the Convention on the Rights of the Child influenced the preamble of the '88 Convention. Another thing to note is that, in fact, the Vienna negotiations were more cautious about the legal obligations being taken on board with regard to drugs. States were cautious over many years about prevention, if they knew what they were talking about, if they knew what they were supposed to do. They were more cautious about whether they should use the use of children or the victimization of children, opting in the end for the latter because it was narrower, whereas the Convention on the Rights of the Child adopted the broader phrase without, in fact, really any discussion of what that might mean in terms of states' legal obligations. In fact, the Convention on the Rights of the Child, the article in the Convention on the Rights of the Child was adopted with very little discussion in the end. I think it was seen that protecting children from drugs was such an obviously good thing to do that the discussion of what it meant to adopt a child rights approach to that didn't come up. And the final thing to note is that whereas in the drugs convention system, incitement was eventually accepted, it was rejected in the Convention on the Rights of the Child. And conversely, whereas in the drug control system, this question of root causes was controversial, clearly in the Convention on the Rights of the Child, with its economic and social rights protections, root causes of child rights problems are more central. So let me just show you very briefly some of the text here. So this is Article 33 of the Convention on the Rights of the Child. I've highlighted the phrase, the clause rather, that links this provision to the UN Drugs Conventions. You can see here that there's another couple of important phrases. We can see that it's to protect children from the illicit use of narcotic drugs. That was intentional. In the drafting, the original wording was to, as I mentioned, to prevent and prohibit children using drugs, but the broader concept of protection was ultimately preferred. Whereas prevention is still used, as you can see, in relation to the use of children in illicit production and trafficking. I've also focused a lot on this phrase, appropriate measures. It's a very common phrase in international law, allowing states a margin of discretion as to what they do. But with regard to the human rights problems we've seen in drug control, this idea of what's appropriate from a human rights perspective has become important. Now, I mentioned that this was somewhat of a unique provision, but it was followed by others in international law. We've got ILO Convention 182 on the worst forms of child labor. And here, in the definition of a worst form of child labor, we have the use, procuring, or offering of a child for illicit activities, in particular for the production and trafficking of drugs, and again, as defined in the relevant international treaties. That was drafted intentionally so as to complement and not conflict with Article 33 of the Convention on the Rights of the Child. And of course, now we see some of that reflected, although not explicitly, in SDG 8, which refers to the worst forms of child labor, though those were supposed to have been eliminated by 2025. It seems, let's face it, somewhat unrealistic. The African Charter on the Rights and Welfare of the Child was adopted in 1990, and this includes a provision entitled drug abuse. And there's some slight changes of wording here from the Convention on the Rights of the Child, and I think it's incorrect overall. And I'll explain why just very briefly. Again, we can see as defined in the relevant treaties there. But the problem here is the omission of the word illicit twice. So here, the Charter states that states should take appropriate measures to protect the child from the use of narcotics and the illicit use of psychotropic substances. This seems like a nonsensical distinction to make. It seems that the illicit use of both is what's at stake, especially when we consider all of the licit uses of narcotics, including the opiates for the control of pain and so on. There's also a reference there to the use of children in production, but of course it should be illicit production. And this would affect, for example, the role of those under 18, for example, in harvests and so on. So I think there's just that the provision was misworded in how it was translated over. On the other side, just to clarify, these are some of the provisions from the drugs conventions I was referring to. So on the left, we've got the prevention and early identification and treatment provision from the 61 as amended and 71 conventions. But as I'd mentioned, this is an implicit reference to young people if we think about prevention and possibly education. The commentary, for example, refers to information in schools. But in the drafting of those provisions, young people didn't arise at all. However, on the other side, we have the 1988 convention, and there we have the preamble. We've got the provision on aggravating circumstances, and we've got the provision on publicly inciting or inducing others. Now, again, that's an implicit reference, but in this case, it was entirely premised on protecting children and young people. That's what it was for, which is different from the one on the left. So it's really in the 88 convention that we see the explicit focus on children. So we have, in effect, a convergence between these two systems around the late 1980s. And we could rather simply see them as therefore being complementary. You've got the preamble that talks about protecting children from drugs in the Trafficking Convention. You've got Article 33 of the Convention on the Rights of the Child. But we have to bear in mind what's known as the fragmentation of international law, that we've got various specialized systems growing up over time, sometimes dealing with similar or the same problems and not necessarily approaching them with the same principles, the same ethos, and in the same way. An example these days would be the approach to indigenous uses of certain commodities and crops in the single convention versus contemporary indigenous rights standards. They're not looking at this in the same way, so different conclusions. They also, of course, are approaching it from different timescales. Here we have, on the one hand, human rights law, of which the Convention on the Rights of the Child is a part, although child rights law is also specialized in its own way, versus the drug control system, which is a combination of commodity control or administrative law and transnational criminal law. They don't necessarily approach things the same way, even if one could argue that they are complementary. They're not necessarily the same legal frame of reference, is a way to put it. For example, the position of the individual is different in each one. In human rights law, the individual is very, very important. The rights of the individual are at the center in being protected. That's not the case with transnational criminal law. The rights of the individual are not referred to very much, at least not explicitly in the 1988 convention. The only place where really it comes up is where there are caveats, such as in the incitement provision, in fact, that certain measures are to be in line with constitutional principles, which implies individual rights within a constitution. But clearly the aim of the drugs control system is a collective goal within, for example, as with public health, of what's sometimes referred to as effective suppression. It's the wording of Neil Boyster. Whereas, on the other hand, we have a different aim within the human rights system of the realization of rights. The realization of rights and effective suppression of drugs might not necessarily coincide. On the one hand, we've got the individual as an object of controls, effectively, within one system via national law. On the other hand, a subject of rights against which claims can be made against the state. So the question there then is, could responses to the question of children's drug use and children's involvement in the drug trade and drug control itself look different depending on which legal frame of reference we tend to use, where we plant our feet? Are we looking at this through the lens of child rights or human rights? Are we looking at it through the lens of drug control legislation? And this, in some ways, brings me to what I said I'd discuss about what these treaties require, which I think boils down to a debate rather than a very clear legal situation. What I did was I went through various literature. I went through the policy documents, speeches, statements from various bodies, as well as NGO reports and academic literature in order to try and categorize what the argumentative structure of the debate looked like. And what I broadly developed as a heuristic was what I call the drug control position and the human rights position. Now, this is intentionally generalized. There's obviously crossovers in what I'm about to say. But by and large, what we have is, in the drug control position, a broad grouping and a broad agreement that the main goal is to deal with drugs problems. The main goal is to reduce supply and reduce demand and achieve what the Drugs Convention set out to do. This helps us inform what the Convention on the Rights of the Child requires, because Article 33 of the CRC is really quite broad and it refers to the relevant international treaties. So the Drugs Conventions inform what appropriate measures under the Convention on the Rights of the Child may be, fills in the gaps in that big broad provision. In turn, then, the Convention on the Rights of the Child effectively reaffirms what the Drugs Conventions require. This is really about focusing on harmony between these two treaty systems, despite the fragmentation of international law. Effectively, what this argues is that children have a right to what the Drugs Conventions require. That's one way of putting it. On the other side, there is what I call the human rights position, and this plants its feet in human rights law, of which the Convention on the Rights of the Child is a part, but not the only thing to pay attention to. Here, the direction is reversed to the extent that human rights law informs how the Drugs Conventions should be read, and in some cases exposes conflicts between human rights law and the Drugs Conventions, the provision on indigenous uses being one of those. In fact, it's premised on the idea that given that human rights law and the Drugs Conventions might approach things in different ways, they're always in a state of tension or potential conflict. So it's human rights law that has to restrain states' implementation of the Drugs Conventions, given that it's in the translation of those international norms into state action where we see most of the human rights problems. Here then, we're looking at tension. On the drug control position, we're looking more at harmony. The human rights position sees a normative hierarchy in which human rights law has a higher status than drug control, whereas the drug control position doesn't see a conflict at all between these two and doesn't really see a hierarchy between different treaties, which strictly speaking is legally the case. Now there's crossovers. All disagree with the death penalty for drug offenses. Everyone agrees with ensuring access to appropriate treatment and so on. But these are different approaches to how these legal systems interact with each other and can lead us to very different ideas of what the treaties require, what they reaffirm, and the kinds of questions that they ask. Now, full disclosure, my previous work has found itself firmly in the human rights position in this. So one of the difficulties with doing a book like this as part of a research project, when you've been involved in the field, is to somehow talk about yourself dispassionately. So the way to do this was to group these things up. And I hope I've done justice to all sides of the debate in doing so. So I think that's a helpful way to talk about this. I will get to what we can fairly confidently say the Convention on the Rights of the Child requires in just a moment. But I think at present, it's very difficult to land very firmly with regard to the relationship between these legal regimes. It seems to me to be better to pay attention to the debate and to see where things currently stand, and then to try and work to make the most persuasive argument, because I don't think this is a situation where there's a definitive black and white answer. I think we have to look at rules of legal interpretation, ethical principles, the best available evidence in order to be as persuasive as possible. And let's face it, that's the job of lawyers and advocates out there anyway. But as part of my work, I wanted to move past the debate, past the history, past what the text says, and past this debate that's ongoing, to what the dialogue between states and the Committee on the Rights of the Child might reveal. So what I did was I looked at all state reports and all documentation from the Committee on the Rights of the Child from 1993 through to 2019. Some are omitted, in fact, because towards the later part of the research, I had to focus on a little bit less. But it amounted to over 450 reporting processes across that period of time, and I think 192 states. Some states reported 4 times, some only once, and so on. So with regard to what the Committee on the Rights of the Child has said about drugs, there's a few things we can say pretty clearly. It's absolutely clear that states have an obligation in child rights law, as far as the committee is concerned, to collect adequate data with regards to the situation. And it's remarkable how little data there is on this, in fact. I mean, outside of the most wealthy countries, really, it's still something of a blind spot, the question of under 18s and drug use. And that's something still to be worked on and supported. The committee has spent most of its recommendations recommending prevention of different sorts. It words this differently. Sometimes it's life skills education, sometimes it's merely prevention. It depends. As well as appropriate treatment. One of the really interesting things with regard to prevention, in fact, is the committee is very consistent on this wording. It says that children have the right to accurate and objective information about drugs, which is, I think, really coincides with the way the UN Office on Drugs and Crime has approached prevention in its prevention standards. And I think there in the future, there could be more information to the Committee on the Rights of the Child on prevention standards via UNODC, in fact, something I'll get to again in a moment. From about 2010 onwards, the committee has become consistent on recommending harm reduction measures for those under 18 who use drugs, but it's never really elaborated on what that means. Similarly with treatment, it's one thing to say that we need youth-friendly treatment, as tends to be stated, but it's very difficult to understand just now what that means if other child rights provisions are taken into account. Another thing the committee has been consistent on is that children who use drugs shouldn't be criminalized because of it. And I think that's in keeping with the committee's effort to decriminalize child behaviors in various other sectors. On top of that, the committee tends to refer to alcohol and tobacco in relation to Article 33, which I think, strictly speaking, is contrary to the provision, which explicitly excluded those substances. But over time, that's not really how states develop their drug strategy. So what states have been doing is reporting alcohol, tobacco, and other drugs together to the committee, and it's been folded into the same kind of commentary. So maybe the original intention of the provision has somewhat faded away, which does lead to a question now of whether the Framework Convention on Tobacco Control is a relevant international treaty for the purposes of Article 33. I tend to see little reason to not think so, and maybe it would be helpful to imagine it as such. There are, however, a number of neglected issues, and this is across the whole periodic reporting process. We don't see much. In fact, I didn't find anything on access to controlled medicines. The only close reference was a recommendation to strengthen child palliative care to Belarus almost 10 years ago. But while the convention is to protect children from the illicit use of substances in the relevant treaties, the obvious flip side of that is the illicit uses, and that hasn't come up. It hasn't come up either in relation to the child's right to health. The issue, access to medicines, comes up, but not access to controlled medicines in this treaty system that's referred to in the convention. Parental drug use in pregnancy doesn't come up very often, but it comes up a little bit. What really gets omitted is supply side issues. So children's involvement in production and trade just really rarely comes up. Now, partially because there's fewer states that would raise that, fewer NGOs that would raise that with the committee. Where it did come up is in relation to children's involvement in coca picking in Colombia. But even then, that's 2006 and really wasn't followed up on later on. And another issue that relates to my next slide is that the committee has really not focused on the effects on children of drug control efforts. So all of these efforts that states put in place to control drugs based on their international drug control obligations and their national law, what are the actual effects on child rights of doing that? This really hasn't come up in the discussion at all, and I think from a child rights and a human rights perspective is something of an omission, which relates to my my next slide here, which is when we look at what states report to the Committee on the Rights of the Child. In other words, if states are submitting their report every few years to this committee, they're telling the committee what they've done to implement the Convention on the Rights of the Child. What we tend to see is states, and this might sound very inevitable and obvious, reporting their criminal drug laws. So they say, we have criminalized all of these behaviors, and we have very stringent penalties for these kinds of activities, and so on. And what we have is a reticence from the committee in challenging drug laws when they're reported to the committee as a method of implementing child rights. So states will tend to equate stringency of their laws with child protection, and the Committee on the Rights of the Child is very reticent in challenging that. Some states, for example, will report that to protect children, they criminalize drug users, and the committee doesn't challenge that. On the other side, or they will say, for example, that they double or triple penalties for certain offenses if children are involved. And there, in some cases, we're talking about penalties of up to 30 or more years. And the question of the proportionality of those sentences really doesn't come up. On the other side of that is what I call uncritical welcoming of drug laws and strategies. And really, that's where a government would say, we've adopted X law, or we've put in place a new strategy, and the committee welcomes it in a positive sense, but doesn't appear to have read it. And this goes up to and including, for example, the welcoming of a drug treatment center that was later exposed by Human Rights Watch as being basically a drug detention center and horribly abusive. But it also includes some other new drug laws and strategies that at the time contained very problematic issues. One of them, for example, was the earlier drug control legislation in the Philippines, which still included the death penalty for drug offenses. And this was welcomed by the committee, indicating, I think, that it hadn't been read. The assumption there is that stringency equals child protection equals implementation of Article 33. And here we see, I think, one of the more problematic things that I found, which is a passive stance from the committee when states themselves say they do things that are problematic from a human rights perspective. And they're telling this to the committee openly by way of saying, this is how we implement the Convention on the Rights of the Child. So states have said that they've raided ghettos. They've said they've denied passports, conducted urine testing, had an all-out war on drugs, as one state said. But I also found, I believe, 17 states that said that they implement the death penalty for drug trafficking as a means to protect children from drugs. And some of those states said, because they've signed up to the 1988 Drug Trafficking Treaty, they implemented the death penalty in order to live up to that treaty, which is not required by that treaty. And then at the same time, in doing so, it will help them live up to their Article 33 CRC obligations. And the committee never challenged this. It's an obvious canary in the coal mine, really, for human rights problems. So there's a number of things going into this, and I wanted to be very fair to the committee because there's a load of practical barriers a committee like this faces that I'm sure those of you who maybe work with the INCB also know. The workload is huge. There are 196 states parties to the committee and to the Convention on the Rights of the Child, all of them reporting every so often. Stacks of documentation, massively high. There's a turnover of committee members and a loss of institutional memory. And there's a problem with expertise. And here I interviewed some of the committee members. And here one of the committee members said, and this is a challenge to our UNODC staff friends, where is UNODC? Meaning that a kind of divide between Geneva and Vienna that we all know has long kind of been standing has affected the work of the Committee on the Rights of the Child. It has an information gap that it can't really fill itself. And the lead agency for drugs could maybe pay more attention to the fact that every 3 times a year, states are reporting to the Committee on the Rights of the Child what their drug laws say and what they claim they're succeeding at doing. So the upshot of this is that we have something that I've kind of see as norm transfer. We're running out of time, so I won't dwell on this, but states take on board obligations under the drugs conventions that they didn't necessarily take on board under the Convention on the Rights of the Child. Now, the reason that matters is that there's still some parties to the CRC that are not parties to the drugs conventions. It creates independent obligations. But via the drugs convention, states adopt national drug laws. They shape them on what's required by those treaties. They develop their national laws and then they report those to the Committee on the Rights of the Child as fulfillment of the Convention on the Rights of the Child, right? So this tends to mirror what I previously described as the drug control position, that it's what's in the drugs conventions informs what Article 33 requires. And a good example of that is incitement. Again, this vexed issue, because it was rejected in the drafting of the Convention on the Rights of the Child. But many states report it back to the Committee on the Rights of the Child as part of fulfilling the treaty, from which it was never included intentionally. So we have this kind of a norm that was accepted in the drug system via the reporting process coming back into a system from which it was explicitly rejected. I think things are changing, though. This is my second last slide, in that this is an open letter from various UN human rights mechanisms, including the chair of the Committee on the Rights of the Child, feeding into the UNGAS in 2016. And you can see that this issue of protecting children is more and more being seen as a potential problem in terms of human rights, that there has to be a demonstration that's what's being done is human rights compliant and effective for the protection of children. These are the basic standards that would be required. So in my final slide, I just want to make a plug, if that's okay, for the International Guidelines on Human Rights and Drug Policy, which includes a dedicated section on children. And here what we've tried to do is to pull together child rights standards to try and develop a few basic standards that states can look to see if they're living up to their child rights obligations while at the same time complying with their drug control obligations. So this is the website that you can look to for that. And I'm happy to speak to anybody that's interested in the guidelines or anything I've discussed. Thank you very much for listening.
Thank you, Damon. Incredibly, yeah, I just thought it was a really great presentation and sort of really concisely, well, rushing through history and looking at the way all the conventions, came to be and then intertwined with each other. I am just curious. I mean, until I started looking into your book, I don't think I'd spent the amount of time you've spent thinking about how these different things actually conflict and get very complicated. So no, I really want to thank you for helping to elucidate that for us. I will open up the floor for questions if anyone has questions. I'm just going to check the chat. Please feel free if you do have questions, be brave, ask away. And you can either raise your hand or type a question. Okay. Would you say, from your experience, while we're waiting to see if people would like to ask a question, that you've seen particularly good examples where a particular nation has managed to balance the conventions together in a way that isn't so negative? Oh.
Okay, yeah, well, we can start with your question and then take the one in the chat. I think sure. I think the question, it's almost like too big a question. I don't mean that to be a cop-out. I think the better way to think about it is something really specific, like, and there's a real role, I think, for diplomats here to explain these things at the Commission, where something was changed, for example, nationally, explicitly because of concerns about human rights, whether that's how treatment is delivered. For example, maybe a requirement for urine testing in front of staff was eliminated because of questions about dignity, right? As I would say it should be. If that was changed, we can talk about these things in human rights terms and learn from them that way. I read, for example, based on the guidelines here, recently a judge in Albania, we did some training in Albania based on the guidelines, and a judge there said that having learned about the human rights aspects of things, it allowed her to look at her options in terms of sentencing in a new way. And it helped her to keep a couple of people out of prison that she thought didn't need to be there. And I think these kinds of stories need to come back described in human rights terms, because I think a lot of good work gets done, but it doesn't get described as human rights progress. And I think that's maybe one of the things to build on.
No, absolutely, and completely valid point. So let's have a look at our question in the chat. Could the author elaborate on the challenges posed by the cyber dimension on drugs and children, please? More specifically, marrying UNTOC with the UN Convention on the Rights of the Child suffice for addressing the challenges faced in these technological eras?
My short answer to that is no. I would say that I'm afraid the cyber aspect of things is not my area. Although I would point to a critique of the Convention on the Rights of the Child, that these days it seems a little bit dated, some people would say. That when it was drafted, the internet was not publicly available. It was invented, obviously, but it wasn't publicly available. And the children's lives these days seem to not reflect some of the theories and ideas that went into the drafting. Now, I happen to think the treaty is capable of adaptation in its interpretation for that, but I don't know enough about cyber strategies and so on to do anything but guess, and I don't want to do that.
Great, thank you. Any other questions out there? Does not look like it. Well, I believe our time is up in any case. I really thank you for making the time to meet with us. We really appreciate it. It's been really interesting listening to you. And for those who are here in Vienna, as well as, well, any of our colleagues who came in from the field offices, we have the book as an ebook. So contact us if you need the information to log in to use it, especially if you're in the field. If you're in Vienna, it's via IP address. We've also ordered the print book, and Patrick, I don't believe it's come in yet, has it?
No, but it's on its way.
It's on its way. Yes, so we will also have the print copy in our collection. Again, a big thank you, and it's been really a privilege to listen to you.
No problem. Thank you so much for the invitation, and best of luck.
Thank you. And thanks to all of our colleagues and members of the permanent missions and so on for joining us as well. So thank you.
Well, if anyone has any questions afterwards, feel free to put them in touch with me. I'm more than happy to answer an email.
Absolutely, wonderful. And there were several INCB colleagues with us today, so I'm sure things will come up later. So.
Well, there we have a specific recommendation. A meeting between the INCB and the Committee on the Rights of the Child would be very welcome.
Interesting, yes. No, I completely agree. But we'll leave it to our INCB colleagues to organize something. Great.
Great. Thank you very much.
Thank you.
Thank you.